If you are making and selling handmade crafts or artwork, one thing you need to research before you start selling is this legal? All right, now I want to preface this by saying that this is a topic I've been wanting to cover for literally years, and it's taken me that long to find the right person to do this collaboration with. By the way, I'm Jen with the Sewing Report, and I'm welcoming in a special guest to talk all about intellectual property, which definitely affects us as makers because there are lots of laws and other types of regulations that cover things that we are going to make and sell. So I'm about to bring in Rob Freund. Welcome.
Thank you. Thanks for having me.
All right, so Rob is an attorney and you cover a lot of advertising and e-commerce law. And I found you on Twitter because you're always posting some really interesting cases or lawsuits involving businesses or even influencers, and it's just fascinating. So I want you to tell us a little bit about yourself and your background in law.
Yeah, I've been practicing law this is my 12th year now. I started at a big law firm called Greenberg Traurig. I was there for close to 7 years out of law school. And what I did there was commercial litigation, mostly defense side. So I was defending big companies and high net worth individuals from commercial disputes, whether it's contract claims or fraud, or a lot of what I was doing was defending false advertising class actions, where some consumers say they were harmed by something that a business was doing in their advertising, and they were trying to make a class action out of it. And so when I decided by the beginning of 2019 that I didn't want to spend the rest of my life at a large law firm and I wanted to start my own thing, my goal was to transition away from litigating and instead help clients avoid those sorts of issues that I was litigating in the first place. And so what I do now is I primarily represent consumer brands, marketing agencies, and individual talent and creators, and I help them make sure that they're complying with the various laws that they need to comply with and hopefully limit the risk that whatever they're doing will result in some kind of expensive dispute.
All right. Oh, and just a quick disclaimer, this conversation is for educational and entertainment purposes. This is not legal advice. You do not have attorney-client privilege with Rob. And if you are looking for legal advice, I would recommend you consult a licensed attorney in your area. Rob, intellectual property, there is, I would say, a lot of misinformation I've seen floating around. And this topic, I know you're not specifically in the Etsy community, unless maybe you're like an undercover knitter or something. But I'm seeing so much bad information being shared, and there's a lot of assumptions people have that are maybe not correct. So that's what we're going to be getting into. So real quickly, I kind of want you to lay out just these specific terms and sort of what they mean and how they're different. Intellectual property, copyright, and trademark.
Sure. So intellectual property refers to creations of the mind, basically. It's an umbrella term that captures a number of creative works and expressions. And intellectual property laws are designed to protect those creative works. And the policy behind it is we need to incentivize, or we as a society should incentivize people to go out and create things. And if they can't protect what they create, then people will be less encouraged to actually do that. So whether it's art or music or crafting or certain kinds of processes or what have you, all of those categories fall under the general umbrella of intellectual property as opposed to physical property.
What about copyright? What does that cover?
So copyright, what it does is it protects the expression of an idea. The language from the law is an original work fixed in a tangible medium. So generally what it covers is things like images, videos, things of that nature that you've created and that have been expressed. It doesn't protect the idea itself, but when you create some piece of media, or in some cases maybe a physical item, then you own the copyright in that expressive original work automatically. And we can sort of get into the difference between registering a copyright and not doing that. But if you're the original author of something that is original and that you've put, either pen to paper or you've actually pressed the shutter button on the camera or what have you, you are the owner of the copyright in that work at the time that you create it. And you have a certain number of rights that are exclusive to you associated with that copyright ownership. You're the only one that can reproduce it. You're the only one that can publicly display it or create derivative works from it, and so on.
And that's a good thing to bring up. Is there a benefit to registering your copyright?
There is, and the benefits have to do with the tools that are available to you in the event that someone infringes on your copyright and you want to take some action to address that. So in order to sue for copyright infringement at all, you have to register the work with the Copyright Office. There's a certain window of time in which you need to do that if you want to have statutory damages available to you. And that's a huge benefit. So what statutory damages are basically is if someone that you're suing is found liable for infringement, then the law sets out a range of damages, an amount of money that's potentially available to you without you needing to prove exactly how much that person profited or how much money you lost as a result of it. And proving up those actual damages can be very complicated, sometimes very difficult to do, and it involves a lot more work. So statutory damages for copyright infringement can go up to $150,000 per work that's infringed. So having that available to you as a remedy is obviously very advantageous. And in order to have that available, you need to register your work with the Copyright Office within 3 months of the first time that you publish the work. And what publishing means can vary a bit, but basically, in an easy example of like a photograph, if I post that photograph to my Instagram account, say, I published it. And so I've got 3 months from that date to register my work with the Copyright Office if I'm going to sue someone later for infringement and have those statutory damages available. So it's important to be quick, or if you're creating something that you want to protect that really has value to you, then it's important to be expeditious with getting that registration secured.
Okay, I had no idea that there was a 3-month timeline. That's good for everyone out there to know. So you got 3 months from the date of whenever you publish the work that you have to register it with the Copyright Office. I did not know that. All right, let's go on to trademarks. This is the one that I think gets people the most confused. But what exactly does it mean to have a trademark?
So trademarks protect branding, basically. The idea is that things like a name of a business or a logo or a signage differentiate brands and businesses and products in the marketplace. So it's designed to help prevent against customer confusion as to the source of a certain good. So if I have a logo like Apple's logo, for example, there was some report, I think a couple of years ago, that said that the value of their logo alone is in the billions of dollars because of the strength of the Apple brand. If they released an iPhone that didn't say Apple and didn't have that logo on it, they're not going to charge $1,000 for it, or they wouldn't be able to. And so trademark protects the goodwill of a brand and helps prevent against confusion in the marketplace as to where a certain product came from.
Yeah, and that makes sense because these big brands, they have spent so much money and so much time establishing the brand. I do want to point, I've got some visual aids here for us today. So one of the big brands is Louis Vuitton, billion-dollar business. And they want to protect their branding because it's, luxury brand. They charge a lot of money for their items. And obviously brands like Apple or Louis Vuitton or any of those really large established, household names, they're pretty fiercely protective over their properties. Is that safe to say?
Yeah, that's more than safe to say. And some businesses and brands are more notoriously aggressive than others, but Certainly the bigger ones are more aggressive, and there's a number of reasons for that. But off the top of my head, the ones that come to mind are Nintendo and Disney are notoriously aggressive in policing their trademarks in particular.
No, that's correct. And a lot of Etsy sellers have had their listings taken down or even shops banned because they were selling unlicensed Disney items. So, and it's sad because a lot of people, I think, when they want to start an Etsy business or they want to start selling something they make, some of them they just genuinely don't know that they're violating someone else's IP. And they look at Etsy and they see thousands and thousands of listings for Disney related items. And they think that gives them the green light just because there's so many other people doing it. They're like, okay, it must be all right. And I see that all the time on online communities. They're like, well, why is it wrong for me to do when everybody else is doing that? What do you think about that sort of like mentality?
Yeah, I mean, that's a question that I get probably on a daily basis in different contexts for different areas of the law. I mean, there's so much non-compliance for many of the legal issues that you can think of. And so I'll hear from clients who say, well, why are you saying that this is a risk when all of my competitors are doing it, or many of them? Or I see so many like influencers not disclosing ads on Instagram, when if that's the law, why are so many people seeming to get away with it? And the answer to that is not a really satisfying one, but it's in many cases it's just luck. The people who are able to police those issues can't be everywhere at once. They can't catch every person that's potentially committing some kind of violation. And so they have to pick their battles, and to the extent they can even identify who's behind whatever that activity is. If you have identified someone as infringing some right, but they're located in China, for example, behind, multiple layers of business entity over there, it's going to be much more difficult to take action. It's not impossible in every case, but it's a combination of just, if there's a volume of non-compliance or infringement that's impossible to really play whack-a-mole with 24/7. And in some cases, depending on who you're potentially infringing, they might not care as much as other businesses are. But it's a mistake to think that just because others, or even many others in whatever market you're in, are engaging in some kind of activity, that means it's safe, and that means that it's okay for you to do. But it also, the other thing that's worth mentioning is, just because you've seen someone else do it, you don't know whether they have gotten in trouble for it. I have visibility into what cases are filed in federal and state courts. I try to stay on top of it, but we have no way of knowing how many demand letters get sent out and how many disputes have been resolved outside of the courts informally through confidential means. So that person that you see, or that business that you see seeming to get away with it, may currently be spending a lot of money on legal fees to try to get themselves out of some situation.
Yeah, that's a good point. I'm a former media veteran, and the workplaces I've been at, the TV stations, networks, they actually get sued quite frequently, but you never hear of it because, it's not public. So you only see what you see on the surface, and there could be other stuff going on that you just don't know about. Okay, so I think it would be helpful for people to bring up, we're going to go over a bunch of different examples of like copyright and trademark potential infringements. So we're going to have some fun here, Rob. Are you ready for this?
I'm ready.
Okay. So one thing I see a lot, and this is something that I think people are, not quite knowledgeable about, is fan art or artwork that people will draw or make, and it's of licensed properties. So I'll see someone on an Etsy seller forum and they'll say, well, I'm not infringing IP because I drew all of this myself, or this is something I created. But the thing they've created, while the work itself is quote unquote original, it's of Star Wars or it's of Pokemon. So can you explain what kind of violation that would be?
Yeah, you potentially have both of the broader issues that we talked about. There's copyright concerns and potentially trademark concerns. A business can own a copyright in a fictional character if that character is well delineated enough and there's enough specificity in that character. So even though you might create some piece of artwork that puts that fictional character in a unique and original environment, or maybe exaggerates some of their features or whatever touches you've put on it, you still could potentially be infringing on that business's copyright to the character. And you can imagine that if you wanted to play the devil's advocate sort of role, if this is a business that sells a lot of custom prints or posters or imagery of that character, and that's a big revenue stream for them, and there's maybe a seller of fan art that's doing a lot of business, maybe that business that owns the copyright would see that as a threat that they want to put an end to from a copyright perspective anyway. From the trademark angle, if you're incorporating the logos of whatever the IP is that you're trying to use, like if you're selling an image and you use the Star Wars logo in it, then you potentially have a trademark problem on your hands there. Or if you're using, the Pokemon logo as part of the fan art or something like that. And brands have an incentive to be more aggressive about trademark issues in that kind of context than copyright ones, because trademark's kind of unique in that if you don't aggressively police your trademarks, then when serious infringement happens down the road, or an infringement that you as the rights owner really care about, you can lose the argument that you're entitled to enforce it if the infringer can show, look at all these times where they did nothing and they sat back and they're not actually policing it, and they've allowed the brand to be diluted, and arguments along those lines. So there's an incentive to try to police everything from a trademark argument so that you don't lose that protection when it really matters for the brand.
All right, Rob, you may not know this, but I'm a big BTS Army. Do you know what that is?
I know what it is. I couldn't tell you any song titles, but.
Okay, so I've got some BTS stuff in my background here, and they're based in, this is a K-pop group based in South Korea. I'm a super fan, and they're known by specific colors, so like black and purple. So even if I'm not necessarily, if I'm making, say, black and purple items, like say black and purple knitted hats, and inherently you would be like, okay, that's all right. But if I was, say, selling them on Etsy, like BTS Army hats, I'd probably run into some issues, right?
Yeah, you'd be running into the trademark issue there, because you'd be invoking the brand's name in connection with selling a product. And so that would be a not very complicated trademark claim to bring. But if instead you said something like, K-pop purple and black knitted hats or something, that's generally going to be safer from a legal perspective, because you're not using the specific trademark names, and instead you're just sort of describing it by color and broad genre of music. Even if people could deduce what you're aiming at, BTS would have a harder time arguing that a reasonable customer would be confused about whether that's there's some endorsement or connection between you and BTS there.
Okay, yeah, so that may be a way if you want to try to do something around a specific community. If you kind of use more generic terms like K-pop or I don't know if you could do Army, because they might have Army trademarked somewhere, but you would definitely have to do some research and figure out like what they have trademarked and what might be safe. But that is really good to know. And another, I know this from firsthand experience, one property or like entity that does tend to really crack down is anything sports related, college sports, professional sports. Man, the Olympics, they're super hardcore. So I have seen a lot of people selling things in different colors. Like gold and black for the Pittsburgh Steelers, or I don't know, was it like red and white? I don't know, the Kansas City Chiefs. So a lot of people are making things in like team colors. And could those things be trademarked as well?
It's conceivable. There are brands that have trademarked specific colors and hues, like Tiffany has their blue color trademarked. I don't know whether any particular NFL team owns the trademark in the combination of very specific shades of colors. Like, I don't know if there's a certain yellow that combined with black, maybe the Steelers have some kind of rights over. But generally speaking, if you're just selling in Pittsburgh a sweater that's black and gold, there's not going to be a risk of that just because some people could draw the connection between that and the football team. But if you had just sort of a generic black and yellow sweater and the listing said, Steelers colors, then that gets back to the issue that we just talked about, like with the BTS hats. So the issue of colors by themselves can be complicated depending on who owns what rights, if any, in a certain, like a particular color or combination of it. But generally speaking, just using colors without identifying marks or names is less likely to be considered infringement, unless it's so distinctive and so obvious what you're doing that you could maybe say, all right, there's somebody might think that this is associated with that team.
All right. Well, that's good information. I think that's why I'm glad we're talking about this, because it is so nuanced and there's a lot of gray areas. So it's not like you can make blanket statements on what's okay and what's not okay, because the answer is it depends. Okay, so this is huge in the sewing community, is licensed fabric. So big box stores, Joann's, might be selling licensed fabric that is of trademark characters, Hello Kitty. I've even seen Star Wars fabric. I've seen them sell licensed NFL fabric. And on the fabric bolt, it will often say not for commercial use or for personal use only. But I have seen some discussions where people are just like, you can just ignore that. The first sale doctrine protects you. They can't do anything about it. What do you think about licensed fabric?
So starting sort of at the end of that question, the idea that the first sale doctrine protects you from anything that you create from licensed fabric is a mistake. If you were to just resell the fabric itself unaltered, then yes, you can do that because you're not arguably creating any kind of derivative work or anything like that. I bought this product and I'm reselling this product. But it's not true that would protect you from turning that fabric into a scarf or something. And then, like, if you had Harry Potter licensed fabric and you make a scarf out of it and then sell that as a Harry Potter scarf, the first sale doctrine really doesn't have anything to do with that, or at least it wouldn't protect you in that sort of situation. So especially if a big business is selling you something and telling you that it's for personal use only, there's a reason they're telling you that, and it's not just because they don't want you making money. It's really telling you, like, heads up, this is something that we'll police and that we take seriously. And so the issues and the strategies that we've talked about already apply there too. If you're going to turn that into something, turn that licensed fabric into some other product, you want to limit the extent that the character or the name Harry Potter or something is the centerpiece or the main focus of that item. You don't want to use that character's name when you sell it and things like that. But I mean, generally speaking, what I'd recommend is if you bought something that said it's for personal use, don't use it to create something that you intend to sell without really carefully considering how much you changed it, what is the end product that you've made, how might someone look at that, how might the IP owner look at it. And, unfortunately, some of these answers aren't really satisfying yes or no. Like you said, there's a lot that goes into these kinds of analysis, but like many things in law and especially IP law, it's really fact specific, and it's hard to give a blanket recommendation without seeing the individual creation and what went into it.
Yeah, that's a really good point. Okay, so we have to talk about something else that's very common in the handmade world, and that is making items that sort of complement an existing item. And one example of that would be selling clothing for American Girl dolls. I am seeing a lot of sellers selling, clothing or accessories for different types of dolls, or maybe Barbie dolls. And what kind of guidance would you give on someone that was, making something that went along with an existing product?
Yeah, I mean, there's nothing inherently unlawful about making clothes that fit another product. What you would want to avoid to limit risk of some kind of infringement claim is if I'm making clothing that I intend for people to put on an American Girl doll, it should not say American Girl in the listing or anywhere else in connection with advertising that. You could say, 18-inch doll clothes, or if that's their size, or clothes compatible with popular dolls or something like that. And really, like, what a lot of these issues keep coming back to is you want to avoid a situation where somebody could argue that you selling this product implies some connection between you and the original IP holder. So, maybe something like clothes for American dolls with some kind of disclaimer that you're not affiliated. It's not something I would recommend. I mean, the starting point it would be just don't invoke the brand name and don't use their names and logos when you're advertising those sorts of items.
All right. And I just thought of another question kind of in connection to that. What about using those products for your marketing, like for your photos? So if you're using the clothes and then you've got the clothes on the American Girl doll, do you think that would be safe, or do you think that would be a bit risky?
It's hard to say. I mean, if it's immediately obvious that that's an American Girl doll, maybe that introduces some more risk. But generally, I would say it's certainly not as risky as using the term American Girl in the ad or in the listing or anything you're doing to promote it. To be honest with you, I don't know how much that cuts for or against a potential infringement claim. And, that the part of the job is saying, I don't know sometimes. I don't know if there's a case out there that's addressed that, but I wouldn't put that in like the dark red risk category.
Okay.
If that's the only thing that's in a piece of content is like the existence of the doll, that's not something where I would have a knee-jerk reaction to say you should really stop doing that. Whereas, a listing that says American doll or American Girl clothes, and then or also implies some kind of connection, that would be in that sort of you really should not do this category.
All right. We're going to move on to a really hot topic. And this one, I've seen opinions all over the place on it. And I'm really glad we are going to be diving into this. And that is upcycling existing products. This is super hot. I know sustainable fashion is all the rage. So there are a lot of very popular social media creatives who are taking items like they'll thrift. I know a guy who does this actually. He just finds items like they're branded, like they'll be like a Taylor Swift blanket or a Nike shirt, and he will turn them into kind of new items. And another thing I'm seeing a lot is people taking Nike shoes, they're custom painting them, and they're selling them as like Nike custom shoes. And then we've also got, the people who are taking, this is probably one of the most common examples. They are, say, getting like a trashed Louis Vuitton or a Gucci canvas bag. They're cutting up the material and they're making wallets. They're making other types of accessories out of that like repurposed material. Now, I've seen people justify this by saying the first sale doctrine would protect them if they obtained the item legitimately and it's authentic. So they're like, it's not counterfeit, I'm good. And I've also seen people say that, like, again, yeah, they're like, as long as I'm obtaining this legitimately, it's fine. What's your take on this? And do you have some thoughts?
Yeah, I think this is a situation where people are taking the idea of the first sale doctrine and trying to have it cover more than it actually does. If I buy a pair of Nike, like my white Air Force Ones. If I want to go resell those on eBay, I can do that because of the first sale doctrine. I bought the thing, I own it, and I'm reselling it as it is. But if I were to, break those shoes down, I don't know why I thought of this, but like, and create 2 smaller pairs of shoes or something in like a half the size, I can't do that. The first sale doctrine doesn't cover it because I'm creating something new, and by selling, and that's not a right that I have under the first sale doctrine. So brands have brought enforcement actions they have sued for infringement for custom sneaker sellers, and the mischief case is one of the more recent and popular kind of related examples, where the brand is saying, look, you're reselling this, you've maybe painted the shoes, or you've bejeweled them, or done some sort of modification to them, and that infringes on our trademarks because they're probably thinking maybe we want to sell something in that colorway, or people might be confused as to whether we have some kind of relationship where we've tapped this artist to make Nikes for us. Even if that's not true, they can argue that this is the impression that you're putting out to the marketplace by selling these products. So in the context of somebody taking old Louis Vuitton product and creating a wallet or a small handbag out of it, that's even a clearer problem, because again, those are like the exact products that this brand makes. And the first sale doctrine says, if you have an old LV wallet, you can resell that to somebody else, but you can't take that and then make, trinkets out of it that show our branding and are advertised and sold because the value in it is that it has the Louis Vuitton logo and branding on it.
Yeah, and I think one of the big issues with like the canvas items is that the trademark property is all over the item.
Right,
so even
exactly.
if you're not inherently saying Louis Vuitton, like the one guy, I guess Louis Vuitton sent like a private investigator to his house or something. It was super crazy. He got like 1 million views on his video about it. And they accused him of using like counterfeit material, and it wasn't, and he was like, I'm not doing anything wrong. But I was like, the problem is that you're selling these products that have another brand's IP all over it. And even if you don't specifically say this is a Louis Vuitton wallet, let's be real. The reason a lot of people are buying that item is because it has that designer brand on it. So I do think the brand could probably argue that another business is using their IP to make money, because like, would you pay, this now is like $760. I'm not freaking kidding. Would you pay $760 for just a plain item that had no branding on it? There are a lot of these upcycling businesses that I do think are going to run into some problems because they're using somebody else's IP to sell their products. And, like if I was to make something like this out of quilting fabric or something, I could maybe get like $50 on it, but add the Louis Vuitton canvas to it, and it's $700. And I, in my opinion, from what I've read, I do think these brands have a pretty strong argument for using trademark to come after some of these businesses.
Yeah, and I just wanted to mention again, it's not like there's no scenario where you could do something like that would be free from a viable infringement claim. There's probably scenarios where you could take a canvas and make a product and sell it in a way where there's no risk that someone would be confused as to the source, and a brand wouldn't have an argument. So I also don't want to give the impression, while I'm saying that on the one hand, claiming that the first sale doctrine applies to all this stuff is wrong, I also don't want to give the impression that like there's absolutely no scenario in which these businesses can get away with what they're doing. There probably are, but I think that it's riskier to assume everything's okay, certainly, than assuming everything's not okay.
That's interesting. And now, another, I think, misconception I'm seeing is that people say fair use would apply in some of these like random situations, but typically fair use wouldn't really apply to like handmade items or artwork. And it seems like it's a very slim argument. And I haven't seen a lot of cases where that was successfully litigated.
Yeah, I mean, fair use itself in the copyright context, especially, it's a defense to infringement. So it's a mistake to think that, well, I have determined that what I'm doing is fair use, and so if I ever got sued, I can just say fair use, and the case will go away. In order to fair use is something that you have to convince a judge or a jury you're correct about in every case. So it's something that's necessarily fact specific. And there's a number of factors that a court has to look at in every situation where a fair use defense is raised. And so basically what you're saying is, like, what I have done would be infringement, except that it's excused in this case because I passed the test that the court's going to look at. And what they're going to look at is the purpose of the later use. Is it commercial? Is it educational or for parody or personal use or something like that? What kind of work was used? Was it something that was purely factual? Like, you can't really have copyright protection over facts. So that comes up sometimes in like documentaries and biographies and things like that. How creative was the original work that you copied? How much of it did you use? Did you duplicate an entire movie, or did you just take a snippet from it, or just some piece of artwork? And then what's the effect on the market for that original work that your use, like, what's the impact of what you're doing on the market? Is the person who created the original one losing out on licensing deals? Is there some other kind of harm that you've done to them? And in every time you want to raise a fair use defense, a court will have to go through looking at the facts to evaluate all of those things. And so the reason I walked through all of that is just to drive the point home that you may have a fair use argument, but it's a mistake to think that that can like quickly resolve a dispute, or that you can ever be 100% sure that you're right, because you might have a great fair use argument and get a judge that just doesn't agree with you based on how they're looking at those factors.
Yeah, that's very true. All right, so there is something we got to talk about, and that is things like movie titles, books, song lyrics, and that's very common. A lot of people are trying to capitalize, makers are trying to capitalize on certain popular trends, so they will make things like for Squid Game, or again, Taylor Swift is huge. In fact, I saw one gal on Etsy did a video where she was like crying and talking about how Etsy shut down her shop because she was selling Taylor Swift song lyrics on like sweatshirts. So I have one of my visual aids here. Now this is a hand towel that I embroidered, and these are song lyrics from a BTS song. So it says, "I'm diamond, you know I glow up." Now I made this for personal use, so that I should be okay in that regard. But what would happen if I were to try selling these on Etsy using, "I'm diamond, you know I glow up" in the listing title? Would I run into some issues?
Yeah, you might, and this is one where you might run into both of the issues we've been talking about, copyright and trademark. So quotes and lyrics can be protected under copyright law, and if you use them in a product without permission, that could be infringement, especially if the quote or the lyrics are a significant part of the work that you're drawing them from, and that's why that work is famous. More common, though, is artists will trademark titles or lyrics because they want to put it on merch. So you'll see that a lot with singers after they release a single, or even before. That you'll see on the trademark site, the trademark office's site, applications for quotes and phrases and parts of lyrics that artist or whoever owns the rights to the song wants to protect. So. It's another situation where you want to, if you're dead set on selling something with lyrics that everyone will recognize or a lot of people will recognize, do your diligence and see whether there are trademark applications pending or already live on the USPTO's office. And if there are, then you know that it's even more risky to try to sell something with that on it.
Huh. So if something is not registered with the USPTO office, but it's still like a song lyric or something, is that still kind of risky? Like, even if they haven't trademarked it, but it's in like a song, or it's like a super popular quote?
Yeah, I mean, we're talking about a spectrum of risk at this point, and so is there still some potential risk from either a trademark or a copyright perspective? Yes, but it's certainly going to be less than if you see, okay, I don't know if this is true, but for example, if Taylor Swift has, I'm blanking on Taylor Swift lyrics,
It's
even
all
though
right. I'm not really a
I'm
Swiftie
well
either.
versed. um, yeah, I mean, if you see that she's got a registration for a famous line from a song, then that would be something you'd want to avoid. But it's not the case that you're 100% for sure in the clear just because you can't identify anything that's registered relating to the IP in a lyric or a quote. It's possible that the artist would still have a valid claim for infringement. But it really just depends on who the artist is and what the song is and what the status of their IP registrations are and how you're going to use it and where and why and all of those sorts of things.
All right, something you talk about a lot on social media is celebrity and publicity rights. All right, so I've got an example. Are you a Keanu Reeves fan, Rob?
Yeah, I like Keanu Reeves.
All
I
right.
feel like he's probably one of the most widely
Yeah.
liked people.
Yeah, he seems so cool. So I
Yeah, he
purchased
does.
this a few years ago, just as like a joke. I'm not like I'm not like a stan, but I just thought this was funny. So it's an adult coloring book where it says crush and color, and they have like a popular male, celebrities. I think they also had a Serena Williams one as well, or something like that. It says Keanu Reeves, colorful fantasies with a mysterious hero, and then you can color, and this is one I did. I did this in a video where they have like it's not exact scenes from movies, but you can kind of tell which movie they're like referring to, and it's all picture. Okay, here we go. So it's all photos of him in various scenarios, and you can color Keanu. So this would have to go with more like publicity rights and licensing his his name. So what would someone have? What would this company, Castle Point Books? What did they have to go through to get this crush and color book made?
Yeah, you're right that this more squarely raises a publicity rights issue. So publicity rights protect, everyone has publicity rights, and those rights protect against the commercial exploitation of your name, image, likeness, and in some states, your voice, basically your persona, without your consent. So anytime a business is in advertising or in connection with some kind of product, using someone's name, image, or other element of their persona without permission, they have a problem. And the way to address that is to get a publicity rights release from the person that's the subject of your work. And most often these cases come up, or the ones that I see most commonly are like a brand sees a celebrity wearing their jewelry, for example, and they want to make a post about that either on their website or on their Instagram. And they'll say, look at, I don't know, Jessica Alba wearing our bracelet or something like that. At that point, they have used Alba's name and sometimes her image to promote the sale of a good without her permission. So it's like a pretty straightforward publicity rights claim. And they would need to have written permission in the form of a release or a licensing agreement with that person to avoid being sued for a publicity rights claim.
I imagine Keanu probably got paid for this. I'm going to assume he might not have had deep involvement with the project, but it says you can find romance, intrigue, and smoldering gazes in 35 hand-drawn reveries. So, it's funny to me picturing Keanu like go through this and like, I don't know, sign off on it and be like, yeah, that looks good. I don't know. I just thought these were really funny. I also have the Jason Momoa edition as well. I have not colored that one as well. And this is also my former workplace. So I kind of found this morning. I was like, oh, so this is where I used to work, and I bought this at the gift shop, and obviously they were licensed because it was at the CNN Center, but you can't just start making CNN stuff and selling it, I imagine.
Right.
So they can choose to sell or not sell whatever they want, but I do think a lot of people just don't know that, and they're like, okay, I could just do different brands, or I could sell like Pepsi merch or anything, but you really just can't. You can't just kind of do whatever you want with this sort of thing, right?
Yeah, and maybe you'll get away with it, and maybe you can point to somebody who is getting away with it, but from a legal perspective, that's not something that you're just authorized to do.
And another thing that I think people tend to overlook is that there are a lot of brand names that are kind of used generically, like Kleenex, Velcro. Onesie is a big one in our community because a lot of people will make custom baby items. But people do really need to be careful about using those brand names in some of their, product info if it's like a trademarked brand.
Right. Yeah, there's that's sort of like a fundamental trademark issue potentially, and I can see how that could happen maybe inadvertently. It's just, okay, this is how I refer to this category of product, and unless it's a trademark that's become generic and lost its protection, then you have an infringement issue. So yeah, there are some businesses that I think you mentioned to me that are especially aggressive about it and have even made videos about how to and not to use their name. So it's certainly something to keep in mind if you are using a brand name in promoting anything. And if you're not sure if you are, maybe that's something to pause and think about. Like, oh, is the way I'm describing this, did I just as a force of habit use a brand name in describing this because there's one big player in the market for what this thing is?
Regarding personal use, now, like this towel I made, again, as long as it's for personal use, right, you can kind of do, whatever. Is that risky at all? Or even if I like post this stuff on social media, but it's like I'm not selling it and it's like just for me. Like I've made some BTS stuff. I don't know, I've made YouTube videos, but I don't sell anything that I make. What do you think about that?
That's safe territory. I mean,
Okay.
especially if you're not posting it, I mean, knock yourself out. Like you can do basically whatever you want. I'm sure that if I spend a minute thinking about it, there's probably some exception to that. But if whatever you're making for your own enjoyment, for yourself, and that you're not selling and you're not publicizing widely, then making your own crafts about Taylor Swift or whatever else you want to do is not going to be an issue. If you're posting on social media, you just want to be sure that you're making it clear that this isn't for sale, and you're not doing it in connection with the heart of your business. So what I mean is, like, if you have an Instagram page for your business that creates crafts to sell, then if you're going to showcase alongside things you do sell some item that you recognize would be problematic to sell, then you would probably want to make it clear that, I'm not actually selling this. This is not for sale, something like that. But it's certainly the truth that creating things for personal use is a safe thing to do, generally speaking, but selling things is where most of the risk arises.
Lately, there's been a lot of buzz because Etsy has been a lot more aggressive with enforcing potential IP or IP violations. If someone's watching this right now and they run an Etsy shop where they sell stuff, and they might be in like the high risk territory for what they sell, what are some things they can do right now to try to mitigate the risk?
Yeah, I think the first thing I would do is just sort of do an audit of your storefront and whatever the library of materials is that you're selling. So go through and inventory what listings you have that might infringe on IP, whether it's copyrighted images or trademarks or things that closely resemble another brand's products or something. And when you identify those potentially infringing listings, if you decide it's a risk that you don't want to take, then removing them is a good first step. It's definitely better to err on the side of caution as you're reassessing the things that you're selling. I would say beyond this video, educate yourself about IP laws. I'm sure there are resources out there that go into more detail about whatever specific scenario you're having an issue with. And if that information isn't accessible or you don't want to do it yourself, have a consultation with somebody who focuses on exactly as close to what you do as possible. And the benefit of that is, you can save money down the road through a little bit of prevention up front. If there is something that you think might be infringing and it's within like the realm of possibility to seek permission or a license, that's something that you might want to do depending on what it is that you're selling and who the IP owner is. For products that might be inspired by popular culture or something but aren't affiliated with the brand, you might consider adding some kind of disclaimer, just saying like, I have no affiliation with whatever this business is, because that can sometimes help hedge against some argument that someone would be confused as to the source of the product or something like that. And then just, monitor your new listings and continue to go through and think about these things as you continue your business.
All right, now I will say this. I think one big issue with a lot of people in the maker community is that they're very small businesses. They're often one-person operations, and they really don't have a lot of resources for legal expertise with someone like yourself, even though it would be super beneficial. They really don't have the money to do that. So, but there are people who are getting threatened by big companies, or they're getting legal action taken against them. What kind of advice do you have for someone in that situation who's been threatened by either a business or a law firm? They don't know like a lot of people come to Reddit in a panic because they got they got a cease and desist letter, they've been sued, and these people have literally no money. What should they do? Like, is there anything they can do?
Well, I mean, every situation is going to be different, and I just need to say that again. But what you definitely should not do is ignore the letter or the lawsuit. I will hear from clients from time to time, maybe not with this sort of issue, but sometimes in others, where they'll assume for whatever reason that they can ignore a demand letter, and then if the brand's really serious about it, maybe they'll sue me and we can deal with it then. If someone who's accusing you of infringement or really any legal wrongdoing intends on following up from that demand letter, which many of them do, if not the overwhelming majority, whatever you have to pay to get out of that, it's going to be cheaper the sooner you resolve it. And maybe there's no payment even being demanded. So the first step is like reading and understanding what the notice you've been sent says. Like, what are they claiming you've done? What specifically do they think has been infringed? What's their evidence for that? And then like, what do they want? And if it's not clear what they want, consider reaching out. Like, hey, maybe you're happy to just take down the infringing content, and you say, okay, you don't want to admit that you've done anything wrong.
Okay.
That's where a lawyer can help you make sure you're not saying too much. But if you say, hey, I got this letter, we're happy to take this down. Will that satisfy what you're looking for? And just like see what exactly it is they want you to do. In terms of the expense of hiring an attorney, I'm always going to recommend that getting legal help in any kind of litigation or pre-litigation dispute is the way to go. But there might be free or low-cost legal help in your area. There are, sometimes bar associations will offer discounted rates for like small business clinics or individuals in some situations. So explore what options are available to you. It's not the case that it's like, I either go this alone or I spend, $1,500 an hour with some big law firm. There's a lot in between that. And so I'd encourage anybody to look into what options are available to them. And then just document everything is the last thing. Like if you have a phone conversation where you're talking with whoever sent you the letter, take notes about what was said. Make sure you have records of all the emails and just stay organized with those kinds of communications.
Would it be kind of a bad idea to respond or communicate with this person without consulting an attorney? Would it be a better idea to I'm not saying ignore the correspondence, but before you respond, get legal consult just so you know that you're not saying anything that might incriminate you or hurt your case? Would that be a good move?
Yeah, I mean, I think that in pretty much every case is going to be a better idea than just trying to write a response yourself, because there can be traps that the other side will take advantage of if you word something in a way. Like it's human nature to want to be apologetic and say, oh, I'm sorry, you're right, I didn't realize that this was going on, or something like that. If the dispute drags out longer than you anticipated in your estimation of what's going on, that could potentially be construed as an admission or something like that could be. And so there's value in having somebody at least look at maybe, sometimes I'll hear from people who want a consultation that are like, here's what I'm considering sending back. Can you tell me if this looks okay? And it's not like I'm going to take that kind of project on by itself normally, but just getting a set of eyes on a draft response it can save you the risk of saying something you didn't mean. So it's definitely not like a strict necessity that everyone in every case needs a lawyer to respond to every kind of notice. That's not true, but it's almost always true that there's going to be benefit in having a lawyer help you through that.
No, exactly. All right, so I want to address the folks out there, and I've seen quite a few people say something like, okay, why are big companies with tons of money coming after the little guy violating IP? It seems really unfair. What would you have to say to this?
I agree. It does feel unfair, especially if what you're doing is like celebrating this brand and you're like growing the community, and brands want community engagement and they want like a vibrant community of people who are fans. So it can seem unfair that like, okay, you sent me this nasty gram on big firm letterhead over like a fan drawing. That I get that seems unfair, but sometimes it's out of necessity, and it's not about going after the little guy for them. It's about making sure they're staying on top of the little guys so that when the big guy comes along, they have all the tools available to them to stop that. So that's a big part of how they're looking at it. It's like, we don't necessarily want to bankrupt this individual Etsy seller, but when one of our competitors comes along and knocks off one of our characters or starts selling something that, maybe we had an IP deal, but it expired and now we need to bring some kind of claim, they don't want to have any stone unturned that would give the big fish that they actually care about grounds to say, well, look at all the other times that you weren't staying on top of your trademarks. And so you've essentially lost the argument that we're diluting it or something like that. So it can feel, and sometimes it is just like us versus them, and there's just like a scorched earth approach to policing IP. But it's more often the case that at least a big part of what's at play is it's not really about you. It's about a bigger concern that might happen later.
Yeah, I think that's really good to clarify. It's not like it's not a personal thing. It's not like they're trying to necessarily attack that specific person. It's more about the overall letter of the law, and they do have to enforce their IP, otherwise they could weaken their own protection. So I don't think a lot of people know that, so that's another reason why I'm really glad we're having this conversation. All right, on the flip side, there are a lot of artists and crafters who are having their own stuff ripped off. They're having people steal their idea. Again, they're having people steal their stuff or even steal their digital products. So what are some general things you would recommend to this community to protect their own IP?
Yeah, I would say that registering your works with the Copyright Office and the Trademark Office as appropriate, whether it's a logo or some piece of branding that you want to trademark, especially like if you're starting a small business and you have a logo and you have a name or a slogan that you don't want to have ripped off, or some sort of branding element, then it's a good idea to get those trademarks in place and registered early. And if it's especially like audio or visual works, register them with the Copyright Office. It's not especially expensive to do that. I think that a single copy, well, I don't know the exact dollar figure off the top of my head, but we're not talking about thousands of dollars to register something with the Copyright Office. And it's something that you can do yourself. It's usually more efficient and just easier to, efficient from a time perspective, to have an attorney help you do it. And similarly with trademarking something, a single trademark application, depending on the kind of application you submit, is a few $100s, and an attorney might charge you an hour or two of time on top of that. but it's important to do that if you want to do something about infringement down the road. I would also say documenting your creative process is a good idea, and keeping records of sketches and drafts and what you created and when, so that you have an easier time of proving ownership in certain disputes down the road. And then anytime you're working with any kind of third party, whether you're hiring somebody to help you create a piece of work as a contractor or an employee, or collaborating with somebody else to help you sell something or do ad creative, it's really important to have contracts with those people and make sure that, whatever you've had in terms of conversations with them about who's going to own what, who's going to get paid what, how long do I have to keep stuff confidential if I do, what happens if either of us gets sued for what the other person does. Make sure that agreement sets out all of that in the way that you both imagine, because you'll see contracts, or I'll see contracts from time to time that are pretty short, and I'll hear from one side of that agreement saying, well, what we really said in all these phone calls before we wrote this down was this thing that doesn't line up with what the document says. And a lot of times whatever you said beforehand becomes irrelevant. So to summarize that, have agreements with people you're working with, and make sure that those agreements actually reflect what both of you have in mind.
All right, that's great information. And I think one thing that a lot of people kind of wonder, especially if you're a very small business, is like, at what point in the business should you start doing that sort of thing? Like, if you're just kind of making stuff at craft fairs, like what? I know it's hard. It's really hard to determine when you should start getting your ducks in a row like that.
Yeah, I mean, I would say as soon as the money starts coming in, it's a good idea to get all of that done. Or if it's less of a side project and becomes something that you hope to become your main business or a significant business. So at that point, it's good to do some housekeeping. And if it's a small business that you've started, do you have an entity set up that makes sense for you? Like, have you made a corporation or an LLC? A lot of that's driven by tax considerations, but when you start making money, you want to have some the liability protection you get from having a separate entity, and the IP protection stuff. Once you start getting recognition and money starts coming in, and you see this as something that you care about growing, then it's time to, as part of that housekeeping, get your IP protection in line and get that process started.
And I don't know if it's just me, but it does seem like the enforcement over IP has definitely gotten more aggressive. And I think AI tools, in my opinion, have really sped that up, because it's so easy. It's so easy to scan the internet and find anything now. And like even like Google Cloud Vision, it can recognize what's in a photo, what's in a video. It can detect brands, and things have really gotten sophisticated. So it's never been easier to find potential violations.
Yeah, that's exactly right. Like the tools that IP owners have at their disposal to identify infringement they're just getting better and better all the time. And so you're right. There's more enforcement activity, and it's easier to find infringers now than ever. And it'll probably just it'll continue to get exponentially easier as all of these tools we have continue to develop at that pace.
I'm so glad we're able to talk about all these topics, but I have to say, we're going to get into your real passion, Rob, and that is social media and advertising, because that's something that you seem to have the pulse on all of that stuff, and that seems to be the bulk of what you post about. So I want you to share some just tips for small businesses or makers, just generally regarding like guidelines or tips for social media, especially social media posting, because that's something I do see a lot of folks who don't seem to be aware of all of the potential FTC guidelines.
Yeah, so that is an area that I focus on in my practice, and there's a few greatest hits, so to speak, of issues that come up over and over again, and ways that I see small businesses especially get in trouble. One of them, it has to do with copyright again, And there's a common misconception that this is the misconception, when someone posts something on Instagram or on a platform, it's publicly available, and so therefore anyone can do whatever they want with it, or that you don't own it anymore when you post it to social media. That's not true. You still own the rights, if you created the work initially, to whatever that content is when you post it on socials. What you do is you give Instagram a limited set of permissions with what they can do with the content and what they can let other people do. But you still own it as the person who posted it. And so if you see a post or like a TikTok video or something, and I want to use that on my business's site, and I download it from TikTok and I post it on my Instagram, I am not allowed to do that. Or if I screenshot a picture or something from Instagram and repost it on my page, I have a copyright problem on my hands with that. I don't own the rights to that content, and I don't have permission to use it in those ways that I've described. So the mistake number one is assuming that if it's on a publicly accessible social media page, that you can use it for whatever purpose you want. That's not the case. And then another one has to do with the publicity rights issue that I spoke about earlier. Brands want to talk about when people wear their stuff, even if it's not celebrities. So maybe another creator has tagged your brand in a post saying, oh, I love this scarf, and they tagged you with @ your business name is. The act of tagging you doesn't confer any rights at all. So it doesn't mean that now you have permission to repost that or to use that person's name or a photo of them or anything. So a lot of times the copyright and the publicity rights issues are bundled together. Like, I'm reposting a photo that has somebody recognizable in it. You might have both of those problems. So tip number one is clear the rights to whatever content you're posting on your socials, or evaluate whether you need to do that in the first place. So the other one that you mentioned is FTC compliance. So there's a lot that the FTC enforces. There's a lot of rules under their umbrella. Just really quickly, what part of what the FTC is charged with doing is policing the marketplace to make sure that there's not what we commonly think of as false advertising. Part of that is the concept that people should know when they're being advertised to. And so this relates to influencer marketing, and it's why you see things like #ad and other disclosures. The rule is that if someone is endorsing an advertiser, so if an influencer is promoting a brand, and there's a material connection, is what the FTC says, between that influencer and that brand, the endorser and the advertiser, that the audience wouldn't otherwise be aware of, then that connection needs to be disclosed. And it needs to be disclosed in a particular way that's called clear and conspicuous. So a material connection can be a number of things. It can be payment, which is like the classic, I pay you to make a post. It can be giving a free product to an influencer, or giving them a discount code, or an entry into sweepstakes, or some kind of VIP experience or something like that. It can be an employer-employee relationship. Like if I work for Sony and I talk about how great PlayStation 5 is, the FTC would say, well, you need to tell people, you need to disclose that connection and use #ad, or otherwise say, I work for this company. It can be a spouse relationship. If it's your spouse's business that you're talking about how amazing it is, then again, the FTC says you need to disclose that when you talk about that business. And so one of the ways that brands and influencers get in trouble with this is just not making those disclosures when they need to. And if we could get into the details of like what kind of content needs what kind of disclosure and exactly how you need to make it, but that's generally it. And it's something that everyone needs to be aware of, because the liability is shared between the brand and the influencer and any marketing agency that was involved in creating the content, and even a web designer. The FTC has said, like, if somebody creates a web page that doesn't include a disclosure or something that needs to be included, it's everyone's responsibility equally. So it's not like the influencer can just pass the buck to the brand or vice versa for not making those sorts of disclosures. It's everybody's job, and everyone needs to be on top of it.
Do you think one reason why this is so prevalent is, at least to me, it's because it's so easy to rip off people's content? It's just so easy. You can just take a screenshot, you can like download the TikTok. And I think because it's so easy, a lot of people seem to think, it's okay. I don't know.
Yeah, I think that's part of it. I think another part is, like we talked about, there's so much non-compliance that it's easy to think, well, if this brand is doing it wrong, then it must not be wrong. I must be wrong, that sort of thing. And again, also just enforcement resources like the FTC and state attorneys general can't be everywhere all at once. Although we're starting to see some class action litigation about those sorts of disclosure issues. And it's just like a lot of it's not. It's not intentional. I think there's just a lot of misunderstanding about what you can and can't do and how these rules apply. And there's like an education gap between the people who come up with and enforce these rules and the people who are supposed to obey them.
So one thing that drives me crazy is those Instagram accounts where it's just ripped content. And in the bio, the person who runs the account will put DM for credit or removal. I'm like, the fact that you have to say that in the bio means I think you know what you're doing.
Yeah.
And it's also sad. Yeah. It's sad because I really get mad about that because you're taking works that other people spent time and energy to create, and you're not really creating anything. Like, they're like, we're curating, we're a fitness account, and they're all stealing other people's gym photos. But the DM for credit or removal, I'm like, oh my gosh. And then the other, I think, mistake people make in thinking is that if I credit the person, it'll be fine, And I'm like, no, or say like, or they'll put in that like BS disclaimer, like, I don't own the rights to this,
Right.
I'm like, yeah, that's not going to help you. Like, that's just not. Yeah, it's just not.
Yeah, all of that is basically just painting a target on your back.
Yeah.
And I've seen copyright infringement cases where the plaintiff has alleged, like, I was made aware of this because you tagged me in it. Like, and it's a mistake to think that credit is something that you even like necessarily need to do or that gets you off the hook. It has absolutely no bearing on a copyright infringement claim. It can come into play with like a DMCA scenario where, like, if a photo has a watermark or some kind of attribution content in it and you remove that, then that can give rise to an additional claim. But giving credit, it's so common for people to think, well, they should have just given credit. Even if they had, that wouldn't make a difference.
It's not going to make a difference. And
it will probably flag them to the fact that you have done something wrong.
And people think that's like a benefit, especially with bigger like social accounts with a lot of followers. They're like, well, I'm actually doing them a favor because I'm giving them more exposure because they're a little account. But that's not really how it works, right?
No, and I mean, I would argue the opposite. It's like, because you are such a big account, you're admitting like there's value to you ripping off my content. So that's something you should pay for. Like, you're the big account.
Yeah.
Or
at least get permission. Yeah, reach out and get permission at least.
Yeah, and it's not like reach on a big meme account converts to dollars for the overwhelming majority of people. Like, sometimes maybe you'll go viral or something, and if you're savvy, you can convert that into a business opportunity. But that's like the very rare case.
Yeah. I follow this one artist. She's super talented, Lulu Sketches, and she was a Disney animator. So she actually does like insanely talented works. She did the background scenes for Disney shows. I think she's working for another company now. And she actually has to put in her she did a whole video basically saying stop reposting art. It was a great video, and I'll actually link it in the description box because she pointed out all the reasons why having her content stolen hurts her as an artist. And she has to put in her bio, do not repost without my permission. Do not do that. And she also said that she's had a few much bigger accounts repost her, and it didn't help her at all. So, yeah. And they'll try to be sneaky. Like, they'll try to credit you like 8 paragraphs down on Instagram, which no one is looking at. And it's unfortunate because stealing content is becoming lucrative and it's very easy. It's easier to rip stuff off from other people than it is to make videos or make content yourself. And that's something that I think that's one reason why I really gravitated towards your legal content, is because that's something that I'm, kind of interested in myself, because I do create original content, and it sucks to see people get much bigger and get a huge following off of stuff they didn't make.
Yeah. I mean, it's bad for artists. It's bad for art generally. It sort of ties into my intense dislike for what's going on with Gen AI tools also.
Yeah.
It's like the whole point, like I mentioned at the beginning, of having IP laws in the first place is to encourage people to create things. And so by doing things like I'm just going to repost and take all of the whatever credit there could be or glory from reach and take that from you in a way that I'm not supposed to, or I'm going to train my piece of software on all of your art so that other people can just make stuff that you charge money for. Like, it goes against the core of why we have IP protection as a policy matter in this country in the first place. So I really feel for artists who are frustrated and really upset by this stuff, because it is frustrating and it's not right. And it's not good for people. Like, just from a really like zoomed out perspective, it's not good to just have whatever people create be disseminated without permission and without compensation. It's not workable, in my opinion.
I think AI is going to be it's going to provide a lot of interesting things for you to talk about. That's for sure.
Yeah, I mean, it's not something I enjoy talking about because I get so upset sometimes, personally, but it'll certainly give me a lot of stuff to think about. I mean, it already has. Like, I'm looking at some AI issue multiple times a week now as it is, and I'm sure it's only going to accelerate.
Oh, for sure. Now, I want to ask you, Rob, we've talked for a while. Is there anything we didn't bring up or didn't talk about that you think the maker community should know about? Like anything, maybe something that's a hot topic for you or something that you think would be really important?
I think we did a pretty good overview. If we spend enough time talking, we could probably talk for a week about all the different things that could potentially come up. But I hope that the takeaways are maybe some more clarity about what we're talking about when we talk about these different IP issues, some sort of broad strokes about things to keep in mind. And, when I put content out, it's not with the intention that people memorize it like for an exam. I'm hoping that people will, maybe a red flag or something will be triggered in their memory next time they're looking at a contract that's like, oh, I remember what this says. I should look into this more. Or before they decide to do something online, they think, this is something I should go back and look at before I do it. So hopefully, if not, exact clarity on every potential circumstance, some more awareness and something that people will think about more next time it comes up.
Wonderful. All right. Well, speaking of content creation, you are, besides an attorney, you also create content, and you shared that you're about to really go all in on YouTube. Is that right?
Yeah, that's the plan. Right. Now I have to actually do it. I've bought all the gear.
Said it, you gotta do it. You gotta do it.
That's why I said it too, to sort of keep me accountable. So yeah, it's time to start making some videos. The general idea is going to be, I'm going to be taking the issues that I talk about on Twitter and Instagram in like snippets there and turn them into sort of longer form, hopefully evergreen kind of content that people can refer to.
Well, I actually haven't seen any other lawyers really tackling the topics you're talking about. So I think there's a very large audience for the e-commerce social media law in particular. Like you covered the other day on Twitter, CoffeeZilla and Logan Paul, which is a very interesting lawsuit. And you do represent businesses and influencers, right? Sometimes.
Mm-hmm. Yep, I do that. That's the bulk of my practice is businesses and ad agencies, and then maybe like 10 to 15% is individual creators too.
All right, awesome. Well, I'm excited to see what you do on your YouTube channel. Guys, I'm going to leave all of Rob's links and information down below in the description box, including I did see your YouTube channel. You had like a couple, I think you had
some placeholder right now. I tried uploading some shorts that I just like repurposed from Instagram a while ago, but yeah, work in progress.
I think a lot of our community will be very interested in the topics you're covering. So subscribe to Rob's YouTube channel and follow him everywhere because he posts a lot of really, really great content and insights. Is there anything else anywhere else you want to direct people?
No, I think that's it. I mean, I'm most active now on Twitter, still Instagram from time to time, but that algorithm stopped working for me as well.
Yeah.
So yeah, it'll be hopefully YouTube #1 and then Twitter #2. But yeah, that's it.
All right, well, Rob, thank you again so much for joining us. And guys watching, let us know, what did you think about this conversation? Leave us a comment. And again, if you do have questions, follow Rob. Maybe Rob will answer your questions. I don't know, maybe you'll do some live stream. Who knows? But I think you will have a lot of people coming to you with questions. I really do. So let us know what you think about this conversation. If you'd like to see more like this, also let me know. And like this video, subscribe to Sewing Report Live, and definitely follow Rob Freund everywhere on social media. Rob, thank you so much for joining us.
Thank you. Thanks for having me. This is a cool opportunity and it was fun to do.
Wonderful. All right, I'm Jen again with Sewing Report Live, and I'll see you again in the next one.